Welcome back, warriors. My name is Palmater, and my YouTube channel focuses on educating the resistance and inspiring the next generation of warriors to help protect our people and the planet. Today is going to be the fourth video in my series on the final report of the National Inquiry into Murdered and Missing Indigenous Women and Girls. And I'll be focusing on one key area, and that is sex discrimination in the Indian Act. So stay tuned and find out how this relates to genocide in Canada. Today I want to talk to you about sex discrimination in the Indian Act as it relates to Indigenous women and girls. Did you know that it's one of the root causes of discrimination, violence against Indigenous women and girls, and a primary root cause of murdered and missing Indigenous women and girls? Now, the subject I'm talking about today relates specifically to First Nations. Under the Indian Act, they're also referred to as Indian bands, and the terminology in the Indian Act for Indian registration or Indian status refers specifically to First Nations people. Now, for anyone who doesn't know what this issue is, I'm going to provide a brief overview. But this overview isn't even possible without telling the story of the warrior women who brought us to this stage. Since the very inception of Indian affairs, the government's stated intention with regards to Indians, and that's the word that they used in their laws and policies, was to get rid of the Indian problem. In fact, they wanted to continue with their laws and policies until there wasn't a single Indian left in Canada. When there were Indian kids from all over Canada dying in mass numbers at residential schools, and this information was brought to the attention of federal officials, did they say, "Whoa, stop, we have to end this right now"? No. Their response was, there's no need to change what's happening here because residential schools will help with what they referred to as the final solution for the Indian problem. They also talked very openly about creating a definition for Indians so as to facilitate and speed up what they referred to as the gradual assimilation of Indians into the body politic, essentially legislate them out of existence. And their first and primary target was Indigenous women. They particularly wanted to find a mechanism in the Indian Act so that they could exclude Indian women from their communities and completely sever her relationship with her community. Canada's goal always has been and continues to be under the Indian Act to legislate Indians out of existence. And I bet most of you didn't know that there is a legislative extinction date for every First Nation in this country. And one of the fastest ways to legislate Indians out of existence is to target Indian women and their children for exclusion from both legal recognition as an Indian, often referred to as registration, Indian registration or Indian status, and band membership, so membership in their home communities or First Nations. But by excluding Indian women and their children from status and membership, it goes well beyond that. It severs connections with cultures, with families, with extended families, with ceremony, often with territory. It excludes them from treaty rights and programs designed specifically for First Nations. It is literally a direct attack on both her rights and her culture. But the interesting thing about the Indian Act is that they did in fact target Indian women and their children from exclusion. So there used to be a provision that if any Indian woman married a non-Indian man, she and all of her children lost recognition as Indians and had to leave the community. That didn't happen to Indian men. In fact, non-Indian women who married Indian men gained status, as did all of their non-Indian children. And you might be thinking, well, that doesn't make a whole lot of sense. But it does make sense because they were trying to enact legislative extinction through Indian women and their children, but also cultural assimilation by bringing into First Nations cultures other than their own through the non-Indian women. And this happened for many, many, many decades. Thousands and thousands of First Nation women and their children lost Indian status, lost membership, and were disconnected from their communities through no fault of their own. And many, many First Nations women have been speaking out about this for many, many decades. That includes people like Mary 2X Early, who is very outspoken and advocated strenuously to end sex discrimination in the Indian Act. And when that didn't work, then Jeanette Corbière-Laval, who's from Wikwemikong, and Yvonne Bedard from Six Nations, they both sued Canada under the Bill of Rights. And they were arguing that they should be considered equal under the law and not discriminated under the Indian Act on the basis of their sex. Now, they lost that case at the Supreme Court of Canada, but it wasn't really a loss, because what that loss allowed Indigenous women to do was actually bring another case. And that's exactly what Sandra Lovelace from Tobic First Nation in New Brunswick did. Now, Sandra Lovelace right now is currently a senator, and she has been recognized for her advocacy around this case. She decided to take her case to the United Nations Human Rights Committee to have her case heard about sex discrimination. Now, there's a general rule at the United Nations that they want claimants to exhaust all domestic remedies first. So try to go through your own country's court system to get a remedy. And if that doesn't work, then you can go to the UN. And that's where Laval and Bedard's case comes in, because they had already lost at the Supreme Court of Canada. So that paved the way for Lovelace to go to the UN. And of course, the UN decided in her favor. They said by discriminating against Indian women in the Indian Act, they are throwing them out of their communities, disconnecting them from their cultures, and they have a right to practice their culture together with their community. So Canada was forced in the 1980s through Bill C-31 to amend the Indian Act to reinstate these women. Now, the problem with that legislation, Bill C-31, is that they created several problems. One, they didn't reinstate their kids and grandkids to the same level of status as the men's kids and grandkids. So they created new forms of sex discrimination. The other thing they did is they created a hierarchy. So instead of reinstating these women back to the section that they should have been registered under, they created a new section just for those reinstatees, so that they would always be labeled as traitors, always less than their male counterparts. And many, many of those women who are reinstated literally wore that section around their necks like a scarlet letter. They were discriminated against, often excluded, and still in some areas judged today for that section. And so Sharon McIver from BC decided, like, all of this is wrong, not just the hierarchy, but the fact that she and her kids and many others were still not entitled to be registered. And so she fought Canada. And she won, both at trial and the Court of Appeal. The problem is, Canada's response to this litigation was once again very inadequate. What they did was enact Bill C-3, which only registered a small fraction of those who should have been registered but for the ongoing sex discrimination. It essentially registered one more generation, but in very, very limited numbers. So Sharon said, this isn't what I was fighting for. So she appealed to the Supreme Court of Canada, who didn't hear her case. And so she was left with no other option but to file a complaint at the United Nations. Now, those complaints often take a long time, and so that was working its way through the system. And while that was happening, you have Susan and Tammy Yantha and Stéphane Deschanel suing Canada for ongoing sex discrimination in the Indian Act, and they won their case. Now, that made Canada have to respond and amend the legislation. And when they were negotiating what was going to be in the legislation, when they were studying it before the Parliament, House committees and Senate committees, Lynn Gale, another Indigenous woman, had sued Canada and won her case. This time it was about the discriminatory policies that are associated with Indian registration around unstated or unknown paternity, and she won her case. So literally in the middle of considering Bill S3, the legislative response to the Yantha and Deschanel case, they had to adjust and talk about Lynn Gale's case and come up with a different policy option for unstated paternity. So Bill S3 passes, and here's the really weird and bizarre twist about Bill S3. Canada knew that it's still sex discrimination in the Indian Act and that Bill S3 wouldn't remedy it. So they included provisions in there to actually get rid of the bulk of sex discrimination in the Indian Act, but they decided to pass S3 without those particular provisions in force. So they knew it was discriminatory, they knew in fact how to fix it, but they didn't bring those into force. They basically told all of us, we'll bring that into force someday. Well, equality isn't someday. Equality is embedded firmly in both Canadian law, Indigenous law, and international law. So Canada was here acting like an outlaw once again. They literally refused to eliminate the rest of sex discrimination unless courts bang them over the head and force them to do so. So while all of this is happening, Bill S3 passes, and then Sharon McIver's case at the United Nations is finally decided on, and no surprise, the United Nations decides in her favor. They said exactly what we had been saying, that there's ongoing sex discrimination in the Indian Act. Canada knows it. Canada knows how to fix it because they put those two little provisions in S3 that they didn't put into force. And Canada is violating all of these international laws by not bringing it into force. So they told Canada, you need to eliminate sex discrimination and you need to bring these provisions into force. And this is what we had been saying all along. So at the same time, the National Inquiry has been going on throughout this whole period, and the National Inquiry Commissioners issued a press release, a statement saying, in light of the United Nations decision in Sharon McIver's case, they request that Canada finally eliminate the sex discrimination in the Indian Act. I mean, it seems beyond all reason that we would have to ask for this again. But in fact, that's what happened. So all of these Indigenous women warriors were meeting with ministers, sending correspondence to the Prime Minister, the entire cabinet, lobbying Parliament, lobbying the Senate to say, can you please just finally, once and for all, get rid of sex discrimination in the Indian Act? Because even the United Nations human rights bodies who have studied Canada have all said, Canada, you're in the wrong here. You're an outlaw, you're breaching human rights, you're breaching Indigenous rights. These are fundamental issues that go to the root cause of why Indigenous women and girls suffer so much violence, discrimination, and go murdered and missing. It's the least you can do. But Canadian officials still refuse to do it. So we have a scenario where we waited for the final report of the National Inquiry into Murdered and Missing Indigenous Women. And guess what one of their key findings is? That Canada should get rid of sex discrimination in the Indian Act. So I don't know what else they need at this point to actually get rid of the sex discrimination in the Indian Act, but every single law, both here in Canada, Indigenous laws and international laws, all say they don't have a choice. That to do anything else is not only being an outlaw, but they're actually being a knowing perpetrator of genocide by continuing to discriminate against Indian women in the Indian Act. They literally have no choice but to do it. So the issue is now, are they going to do it and when? We've had no response to the National Inquiry report specific about sex discrimination in the Indian Act. All of these warrior women have followed up They're pleading with Canadians to help push the government to finally end sex discrimination in the Indian Act. It's a scenario that's beyond belief when you consider that it's a root cause of genocide, and literally any given Tuesday at a cabinet meeting, they could pass an order in council and completely deal with this issue. It's one of the easiest steps that they could make in terms of the national action plan moving forward to address genocide. And I think all Canadians need to stand with these warrior women and take steps to push their governments. And if you need some concrete action, things to do, template letters, emails of parliamentarians and senators, you can go to the website of the Canadian Feminist Alliance for International Action, FAFIA, and look on the S3 campaign, and there's a list of things that you can do to help us push the government to address one of the root causes of genocide against Indigenous women and girls in this country. And why is this important? Well, because Canada's always claiming to be a country that's based on the rule of law. Well, the law in this territory is first and foremost Indigenous law, and there is no Indigenous laws that allow discrimination against Indigenous women and children. Second of all, the Charter of Rights and Freedoms, Section 15, guarantees equality between men and women. Even Section 35 of our Constitution Act, which talks about protecting Aboriginal and treaty rights, Section 35 sub 4 guarantees those rights equally to male and female people. It's against the Canadian Human Rights Act to discriminate on the basis of sex, and there's no end to the number of international human rights declarations and treaties that Canada has ratified that also guarantees equality between men and women. And so they just have no choice unless they want to breach their own rule of law and be known as an outlaw internationally, in addition to being known as a country that is committing and has committed genocide. Canada could literally eliminate this root cause of murdered and missing Indigenous women and girls in Canada on any given Tuesday. Whether or not they will be an indication of how serious they are about putting an end to genocide against Indigenous women and girls in Canada. Thank you all for watching my channel. I really appreciate that you come here. Please consider subscribing, liking my videos, leaving your comments and questions in the comment section. And what I will do in the description box is leave a link for the National Inquiry's final report so that you can read that. I'll put a link to FAFIA's website so you can go straight there and take some action in support of us. And I'll also leave a link to my book, Beyond Blood: Rethinking Indigenous Identity. And that book is dedicated entirely to this issue of Indian status, sex discrimination in the Indian Act, racial discrimination, and a lot more details and statistics around these legislative extinction dates for First Nations and what we need to do about it going forward. Till next time, stay alert, warriors.